right.
Recording in progress.
The hour of 2 p.m. having passed, the House Adoption and Child Welfare Committee will come to order. Clerk, please take the roll.
Ness.
Here.
Mussman. Here. Reich.
Here.
Crawford.
Here.
Davis J. Davis L. Deering. De La Rosa. Here. Hernandez. Laha. LaPointe. Olico.
Great. With 8 members present, we have a quorum. Although we are not doing any voting today, just to let the committee know, we are doing a subject matter hearing on House Bill 5129 by Representative Meyer. And just to remind the committee, this is for information only, so and to ask questions and to gain a better understanding of the legislation and what it's trying to do. I would also ask that if there are any witnesses to testify today, that you fill out a witness slip before you leave so we can get that for the record. And my last reminder is when you do speak, please state your name for the record. And with that, the chair recognizes Representative Meyer. Clerk, can you please add Representative Jed Davis to the roll? Thank you.
I want to start off by saying thank you to hearing this. I know that there's amendments and everything else probably to be brought forward. We're willing to do that, but it just seems crazy to me, and I'm going to let Danita talk about what she went through with her child and the fact that we have to change this, because we get a call about every other month from a family being told the only way the state of Illinois is going to supply services for their child is for them to give up custody. Now, DHS will tell us that's not policy, but then why is DHS employees telling families this? Because I don't believe any parent should have to give up guardianship of their child to get services. Danita and her family had been on an emergency list for 2 years trying to find placement for her son, and it did not happen. When she contacted me by a fluke because of one of my people who had worked in my office for a short while, knew I had a very passionate heart for people with disabilities, and this gal was then working at the hospital where her child was, and by the time she contacted my office and I got the phone call, we had less than 3 hours to do something before she had to give up guardianship of her child. So I'm going to let Danita talk about that. This is Danita Dorsey, and we will be glad to fill out a witness slip afterwards. State your name and talk loud.
Okay. Hi, I'm Danita Dorsey, and like he said, we were in the hospital with our son Gregory.
Louder, yeah.
Okay. He had actually thrown a coffee cup at my face and gave me a concussion, and that was how we ended up in the hospital. And I told them I couldn't take him home. You know, we needed to have something done right now. I just could not take him back home with me. And the hospital had told me that I would have to abandon my child and so that the state would step in. But please don't actually abandon him. Just fill out paperwork saying that you're abandoning him, and I could potentially go to jail for abandoning him. But they didn't want me to actually leave. They wanted me to stay there and care for him. And I refused to do that. And so they gave me 72 hours. I could stay there and, you know, let the state try to get him something into a SILA home in that 72 hours. And nothing happened, and I got a hold of Charlie, and he said, absolutely do not sign anything saying that you're abandoning your child. He got me the court date, and we went to court, and the state's attorney, stood up with me and told them that, something had to be done, that Gregory couldn't go to jail with the way that he was, but he obviously couldn't go back home with me either. And the state was told that they needed to put him in the home that day. And it was 17 days later before they put him in the home. We stayed in the emergency room at the hospital for another 17 days after that.
And how many times were we in court?
9 times. 9 times to go to court before they finally went ahead and let me take him to a home.
And what happened when we had a court order that specifically said he was be admitted in the closest SODC to you?
Right. They said the closest one, and when we got down there, they called and said that he couldn't stay there. We needed to take him somewhere north of Chicago. And Charlie got on the phone and made a bunch of phone calls. I don't know who all you talked to, but we were able to stay there.
And those phone calls went to the director of DHS, the director of the SODCs. They also went to reporters saying what was going on. Danita's family had been through hell. Like I say, I don't believe any parent should do this. This happens, like I say, I hear about it about once every other month. And all we want is for everybody to do well. Can you tell the committee about Gregory and what's happened over this it's almost been a year now?
Yes.
Can you?
Yes, he's using silverware now when he eats. I can go visit him and he doesn't hurt me. He doesn't try to pinch me or hit me. I actually get hugs and smiles now and kisses. We were able to take him out to dinner, where we have not been able to do that in many, many years. And he's in a workshop now and actually getting out into the community and doing things. And I find that amazing with him. He's blessed being there. He's come so far.
And after being there only 2 weeks, I remember her calling me and saying, Charlie, he's using silverware for the first time.
Yes.
That for her, all she wants is the best that a child can do. Oh, I didn't have my mic on. Sorry about that. So I think that is huge. 2 weeks later, she said he was making whole sentences, which he had not. He could use a word. He knew what the words meant. He'd never made sentences before. So he's gone from being abusive to working in a workshop. But I have seen these residents sit for 6 months in hospitals where they shuffle them around to whatever room, and maybe one night they're spending the night in a laundry room, but wherever is available, the state of Illinois is not paying for it. I've seen them sit in jails. They will, if they want to have a hearing on a resident, instead of taking from the SODC where he is, they'll leave him in a jail for a week or a couple weeks for that hearing. We had one that was left in jail in solitary confinement for 6 months. We had one in 19 days in restraints in a hospital. And so we just got to find a way that, to help these families, to work together. I don't want to battle DHS. My life would be far easier if we could sit down and have a conversation and not constantly be told, no, 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 no. But we'll go to questions from the committee.
Yeah, thank you very much, Representative. A few things before we go to questions. Clerk, please add Representative Norma Hernandez to the roll. And I just want to say a couple of things before we start questions, because your bill does a lot First of all, I want to say to the witness, thank you so much for coming and sharing your story, and I'm really sorry that that happened to you, and
Thank you.
all I can say is your son's really lucky to have you for a mom, because you hung in there and you stuck with it.
Thank you.
And one reason that I wanted to have this hearing and move forward with this is I have also had constituents with older children, and they have had to make some of these difficult decisions. I've heard it from families when their kids are young, before they even enter the system and start receiving services. They're told, here's a path, and one path is to give up your parental rights to get your child services, and that's unacceptable. As a state, it's unacceptable for any of us to ask any parent to do that. So I'm glad we're having this. I recognize that your bill does a lot of things. We have some agency representatives here to talk about the issue as well, and bring some clarity. I understand they're here to answer questions, but I just wanted to say that I do think this is something to bring up, and I'm glad that we're starting the conversation. So with that, I shall open it to questions, and I saw Minority Spokesperson Reich with a hand, and then Rep. Laha.
Thanks, Chair. Charlie, first of all, explain your bill.
As we drafted this bill to get the attention to get it moving, it does state that whoever brings this forward should be fired. The ASHME union called me for this, and it's like, I'm not after your union workers that are presenting this or being told this. I'm after the people on top that I do really
What
do
does your
believe.
bill actually do?
It calls for the firing of anybody that's telling a parent that they need to give up guardianship of their child.
Is there anybody from DHS here to answer questions? Please.
Good afternoon. My name is Meg Cooch. I'm the Chief of Staff of the Division of Developmental Disabilities.
Thank you for coming. I guess my first question is, can you explain to me where in statute or rule you have something that says that a parent has to give up their custodial or other rights in order to gain state services for their disabled child?
We do not have that in statute.
So why is this happening?
Unfortunately, sometimes there are folks, that my understanding with this case, the hospital was the initiator of the idea that her son needed to, or recommended giving up parental rights. We in DHS and our sister agency, DCFS, do not support that. We are very pro keeping individuals with their families, ideally at home with their families, but as a continuum of care, we have a continuum of care in order to do that. But for our services, actually, individuals need to retain the parental rights to.
But this was apparently an individual who works for DHS who made the suggestion that the mother give up her parental rights, right?
It was DHS?
It was the
We would be really interested in knowing who that person was. In the course of trying to prepare for this hearing, we did talk to and got the notes from the specific experience. I think we were here today to really prepared to talk about the bill itself, and so what we think might be challenges and what we think we're already doing with our sister agencies.
You're here at a committee hearing and you aren't prepared to talk about the bill you're here to talk about?
I'm prepared to talk about the bill, absolutely.
So I guess my point is that if one of your employees made this suggestion, it falls on you to explain why that happened and in effect take responsibility for it as the agency instead of passing it off to the hospital.
Like I said, I would love to know the person's name, and we could address internally if there are retraining, there's correction.
Have you talked to Rep. Meyer about this bill before you're sitting here today?
We did not discuss it, the two of us, no.
Have you tried to contact DHS to talk about this?
I have contacted DHS from the very first day that I talked to Danita.
So what we're hearing here is an agency that's not responding to a representative or a legislator's request to help a constituent on an issue that DHS has direct control over. I think this indicates a lack of institutional control in your agency at the very least. But the fact remains is that if you have rogue employees who are making suggestions like that, what are you going to do about it?
And I am happy to address issues internally if Rep. Meyer and
That's why you're
Ms.
here, and I'm
Dorsey
asking
is
you to
going to
address
share the
them.
person's name. My understanding, based on my communication with the DD staff that worked on this case as well, who relayed also what the ISCs, so our case management entities, also did, was in fact that they had heard that there was this misunderstanding and had corrected it. So prior to any judicial orders or anything like that, that they corrected it as soon as they heard that, in fact, the family was told that they should or could give up guardianship. In fact, they were working and had identified 3 agencies that were considering SILA placement for the individual, is my understanding. So they were working actively with the families.
So why did this lady end up in court?
I think, I'm not sure.
Why did this lady end up in court?
Because Danita and her family had been turned down from 200 different SILAs in the state of Illinois, unwilling to take her son. And they were still demanding that he had to go into a SILA, or she had to give
Who was demanding?
a DHS.
Okay.
To get services, he had to be placed in a SILA, even though for 2 years he had been on the emergency list, and 200 SILAs had turned them down. And then they send 3 more SILAs. Well, how long do you wait while your son's in a hospital?
So where is your son right now?
At the Murray Center in Centralia.
The Murray Center in Centralia, which, having visited the Murray Center in Centralia and having spoke many times with the people, that those people walk on water as far as I'm concerned. So any effort to take a child out of a facility by saying that the only way you're going to get services is to give up custody or relinquish custody of that child, where in your, again, I'm going to go back, where in your mandate, where in legislation or rule does it say that you have the authority to tell a parent that they must lose the custody of their child before that child can get state services?
We do not agree with that. We support families and individuals staying with families and being supported and retaining those rights with families.
What procedures exist to give us comfort of the fact that that is in fact what your policy is and that you're adhering to it? If it's not in statute and it certainly isn't in rule, I'm on JCAR, you're welcome to promulgate rules to bring them before us to rectify this situation. But if a situation exists where a family has to expend money, time, and all the emotional stuff that goes with it, I think it's incumbent upon your agency to do something and do something quick. And I don't have a problem with firing anybody who goes rogue on an agency and goes outside their own authority. But it's your job to make sure that if that happens, you know about it and you do something about it. If you don't have rules, write the rules.
Thank you. And I would be, I'm eager to talk with the representative after this about who the staff person was.
I would hope so, because if you haven't talked to him about it already, and he's already made 20-some, I don't know how many calls to DHS and they've been ignored, that is institutional failure on your part completely. And you're here for a reason, to answer questions, and I haven't heard a solid answer to a question I've asked, except for the fact that you don't have the authority, you don't have the information, you don't have this, you don't have that. I would suggest you come back here next time this committee meets with some answers to the questions that I've got, because I got a whole lot of them, and I'm not going to ask them now because I'm going to get the same crappy answers from you that I've been getting all along.
Representative Reich, I just want to interject for a second. So if there's some information that you want brought back to the committee, if we can get some clarity on that and staff can do that, we would appreciate some of that coming back to the committee, and we can distribute that to everybody.
I want involvement with Republican staff on that as well. I don't want just Democrat staff getting the information and giving it to us. I want our
Absolutely.
staff to be doing that questioning as well.
Absolutely.
Thank you.
Thank you. Representative Laha?
Thank you so much. Thank you for sharing. I'm a fellow mother myself with a child with severe needs, and my heart goes to you. And this had to be extremely hard for you and your family. You're torn between safety of yourselves and loving this child. So my heart goes out to you. That being said, there's a few issues here, actually a lot of issues here. We are seeing a lot of families who are in situations that they maybe can't afford the proper care, or maybe, and I have to say, sitting here and listening to your story has kind of personally triggered me. You know, a few years ago when COVID happened and money was not great for most of us, my daughter, who has quadriplegic cerebral palsy, did not qualify for a lot of services that we were trying to get her. The advice we were given through EI under DHS was to consider a medical divorce, which was to separate from my spouse and to reapply as a single parent, because then she would qualify for more services. That's a problem. It's offensive to me. It's offensive to my family. And I'm really sorry that you had to make these decisions. We trust these organizations to help us navigate these extremely difficult situations. Nobody should be denied services, you know, with at this level of care. Nobody should have to be told to abandon their child to receive this care. So, Charlie, I understand that there's a lot of going on here in this bill. There's a lot of issues I see here that we definitely need to be talk about. Thank you for hearing this case. This is very serious. You know, and I'm not pointing fingers at you specifically. This just triggered something in me. I remember before I even got into the state legislature, having this new child, having no clue what to do, and being told by a state agency, this might be your best bet. That's horrifying.
I totally agree. That's an awful thing, and that should definitely not occur.
And as a matter of fact, I believe that NBC News did a story on that. So we need to find solutions. We need to be helping parents who have extremely vulnerable children, vulnerable populations. That's what our job is as government, is to help people who cannot help themselves. Thank you for this conversation, the opportunity. I'm invested in where this goes.
I would like to say that during this process, 9 times in court, 9 times, this family showed up for court. 9 times the social workers from the hospital showed up for court. 9 times it was the assistant state's attorney showed up for court. Representative Rosenthal and myself showed up twice for court. If this wasn't a rule, why did we have to go to court 9 times to find a placement when he had already been denied at 200 SILAs in the state of Illinois? Now, I want to tell you one other bright spot about this story, though. Besides the fact that Gregory is doing so well, and that I just about cried this last time when she said how they were able to go out for dinner because they could not transport him safely in a car unless he was restrained in that car in a modified box, okay? The other bright thing is Danita is now working for the first time in many years, and where did she choose to go to work? But she's working at a SILA. We're not against SILAs, but some of them are, and many of them are not able to take a resident like her son, which we all need to realize, just as they say, it takes a family, it takes a town. Well, it takes many opportunities. Not everybody fits the same square peg into the same square hole. And I think it speaks volumes that her job now is working in a SILA, helping other residents with disabilities. And, you know, she had a very good visit at Easter. She did miss the Easter egg hunt there at Murray, though, but she had a very good visit with him. But, you know, for DHS to come and say, well, this isn't a rule, but that force this family into court 9 times tells you about their determination to do things their way and not to work with the families that need it most.
Okay, do we have other questions? I know Rep. Deering, I see a hand. Mussman, did you have a question? Okay, Representative Deering and then Representative Mussman. Thank you.
Thank you, Chair, and thank you both for being here and agreeing to the subject matter hearing. I do think this is a critical issue. As a member of this committee, I have had my own conversations with liaisons about DHS and DCFS investigative case files. I strongly suggest that you also, I'm sad it didn't happen before now, and maybe if someone else is here, you did mention something about someone naming the staffer.
I'm interested in knowing, because we want to correct any misinformation that is out there, and particularly coming from DD staff. My understanding when I talked with the DD staff that worked on this case was that actually DD staff and ISCs, our case management group, corrected misinformation that was provided during the initial process in the hospital.
Okay, and to Representative Meyer's point, court continued to happen, so I'm not sure about the intensity of that conversation or the correction, but I do hope that that information can be provided to us all. I've gotten lots of information just this morning printed out about Beacon and interagency agreements, which it does seem to list here that there is a lot of interagency agreement. Knowing that, do you have an objection to the language in Representative Meyer's piece of legislation about creating an additional layer to that interagency agreement about specifically families with developmentally disabled children looking for placement?
What I would say is, I think part of our objection to the current bill as it's written is that, in fact, it's already occurring. So Beacon is the portal that was created so anyone can actually refer someone to services that's a child or youth that they think might need mental health, DD services, or other kinds of services through DCFS. With that, every weekly, an interdisciplinary team meets to discuss each of these cases. So that's why I am encouraged that, in fact, this doesn't necessarily happen since Beacon has started, and particularly and with the IGA, that we are all on the same page, that families should stay together, that parental rights should be retained as priority and first and foremost, and they meet weekly to discuss each of the cases so that they can parse out if someone specifically has intellectual and developmental disabilities, then, you know, DD would be the lead. If they were dual diagnosed, that we might be working with the Division of Behavioral Health and Recovery, excuse me, or DCFS as well, but that we can weekly meet to discuss these cases.
So where was the EPIC breakdown in Beacon in this case?
So Beacon started externally in January 2025, and this occurred in April 2025, and Beacon is for kids. So the bill is focused on children and youth, I believe, and I believe Gregory was an adult.
So would you be open to language as suggested in Representative Meyer's bill that expands that age? I mean, because obviously these SILAs are taking adults, is that correct?
Yes, that would be the adult with disability waiver that we are working to get Gregory into.
Okay, and does that happen within Beacon currently?
No, Beacon is currently children and youth.
Okay, so is there an opportunity for an expansion of an interagency resource similar to Beacon for adults, for example, in this case?
I would argue that there is a process already in place. There's a case management entity, so if someone has intellectual and developmental disabilities and is an adult, they can go to their ISC or case management group and they can sign up if they're in crisis, and we have a specific definition for crisis, which is abuse, neglect, or homelessness. Then they don't have to go on our PUNS list. They can immediately start working to get services, and that means ensuring that they can qualify for services, eligibility, income, financial, as well as clinical eligibility, and then they would work with that case manager to identify the services they're looking for, either in the home or in a separate residential.
In this case, knowing you said what you just said, where was the breakdown for Gregory?
Well, it sounds like from the information I received from my colleague and through the ISC was that they were working with the family when he went, prior to him going into the emergency room. SST, which is our support services team, which is a group of folks that support people with behavioral health needs and look at behavioral plans and work with families and with providers to train folks that are working with people. They were with the family and had pulled back because there was less behavioral support needs, but that there was a rise again, and that they came back in on this case. And so they were coming back in, but then he went into the emergency room, and from there, it was, I guess, 25 days later, it sounds like, but initially in the court, I thought was the 15th. But they went and moved to kind of judicial focus to go towards the SODC rather than keep working within the home and community-based waiver and trying to find a SILA within that. My understanding from that report was that there were 3 groups that were considering the packet, and one group had invited him to come visit, but I don't know the full history. I fully acknowledge, so I just got that snapshot of the last part of it. So I would want to do some more deep dive on the case to see if there's other things we could learn from the case.
Danita, the group that said they wanted him to come for a visit, what did they tell you the next day?
They told me that they were told by the state that Gregory was only violent with me. And that's not true. He was violent with everyone, and they said that they said, well, we'll come see you, and they never showed up.
And in this case, as was understood by the agency, this was not a case of abuse and neglect by a parent. Is that correct?
Correct.
So I think Representative Meyer's bill talks a lot about this very unique situation here, which, as it sounds from his testimony, there's multiple cases. This is, so in drafting something similar, I think is his goal. Not only, I mean, I feel like the bulk of the legislation, correct me if I'm wrong, is about creating this interagency team and coordination, as you are so proud of in other instances that could be applied here. Just one other question. Was the current SILA that Gregory is in a part of an original denial?
Gregory's never been in a SILA. He was never approved to go to one. They
Okay.
didn't want him.
You didn't want him? Or
He'd
they?
been approved for SILA placement for 2 years, but they have never found one.
Yeah, none of the homes wanted him. He was too violent.
Okay, thank you for the clarification. I would just say in closing that members of this committee have started paying attention, and when our constituents come to us with concerns, we're going to see it through to the end. And so obviously Representative Meyer has taken further action. I myself have found myself in a similar situation, writing legislation to address our concerns between state agencies and communication, and very intensive reviews. So I applaud you for your commitment to reviewing the file, and I look forward to the results. So thank you.
Representative Musman?
Thank you. Again, we're so sorry that you have gone through these struggles. We're very glad that Gregory has found a placement that seems to be working for him. I think some of these have kind of been answered, but I just want to make sure that I understand. So Gregory was an adult at the time. Was he on the PUNS list? Yes, and he had been approved for residential care. You just hadn't been able to find him a facility that was willing to accept him based on his current needs.
Right. We had looked for over 2 years to try and find, and we visited several homes, but
He had not become an option for you? Was that ever offered at any time?
it was mentioned, and I had asked if that was something that we could do, and they just, his caseworker kind of downplayed it, and she said, well, we need to try to do all this. You need to exhaust every other thing first before we can go for that route. And our other option was to send him to a home that would take him, but only for 3 months, but they would work very intensely on his behavior. But after that 3 months, I had to bring him back home. And when we got to the hospital, I told them, I said, there's just no way I can do that. I don't feel safe with him anymore. He gave me a concussion, and that's what landed us in the hospital. And while we were there, he broke my foot. And I just did not feel safe going home with him again.
Sure. And while he was home with you, was the state or the ISC, were they able to offer any other services that were attempting to address the aggression, the anger, the behavioral?
Right. He did have a couple of behavior therapists that came over once a week, and, they kind of helped me to help him, yes. And he also had a personal support worker that came in and helped me. But that's about it. And really, his personal support worker was my daughter, and, so he would beat her up too.
I almost don't want to ask, was medication ever tried to help curb
Yes, he was on lots of medication.
Okay. And then what was the impetus that finally made Asila be willing to take a chance on accepting him, and ultimately it turned out very well?
He's not in Asila.
He's not?
No, he's in the Murray Center at SODC.
Gotcha. Okay. So, and it was the court that made that happen?
The court made that happen, yes.
Okay.
Yes, they wouldn't take him until the court absolutely, well, even after the court told him that it had to be done, it was still another 17 days later.
So, Meg, does DHS keep records on incidents like this, I guess, where a person like this becomes recognized by the system? Are we documenting that this is a thing that we see repeating itself over and over and over, or is this sort of an outlier element where a series of cascading things failed this individual and the system didn't work, but for many people the system does work as designed?
Thanks for the question. I would say for many people, the system does work. I would also say that we've worked over the last few years, frankly, with the legislators' significant help and the governor's leadership to invest more in the community system that supports 25,000 people in the community with intellectual and developmental disabilities. And so one of the things is supporting people with higher behavioral support needs, higher potentially medical needs as well, and that's something we've worked to invest. We've updated our rate methodology, so how we pay for providers to support people with those higher needs based on their assessments. So it's tied to assessments, and those assessments are up to date. We talked about, you referenced the stabilization homes. We've added those, and actually we have grown those, thanks in part to funding in the budget from just short-term stabilization homes that are supposed to be about 90 days, and the person does return either home or back to their SILA or wherever they were previously, what their home is, and that offers kind of wraparound, more intensive behavioral support services for a period of time. We've actually expanded those to long-term stabilization homes that will allow for that for folks that don't necessarily have a place to go. So this actually would have been good for Gregory, and those are coming online this year. We just did a request for application for those. So we're very excited about those, because some folks, especially if they're coming from the hospital or they're coming from a situation that they can't go back to, it does take a little bit longer, both for stability, but also to identify that next step of the permanent home ideally with a SILA in the community.
Okay. So do you mind if I ask, how old is Gregory now, and how long has he been at Murray?
He's 28, and he's been there a year this month.
Okay. So as he continues to get older, and my understanding is for many individuals that experience a period of aggression, that does tend to taper as they age. And if he is seeing successful behavioral interventions at Murray, does the state have a plan, or have an intention to have a plan, to ultimately step him down to a less expensive, more community service-oriented provider, or he's in Murray forever?
So we're all about choice. Right. So certainly we would encourage folks, as the Supreme Court tells us, to based on the Olmsted Supreme Court decision, to live in the least restricted, most community-based setting possible. That being said, folks are able to determine if they want to, where they want to choose to live, and we strongly believe that, and we strongly believe in the continuum of care. And so we would certainly encourage transition. We have done a lot over the last few years to identify ways to identify the issues and barriers that pose problems with people transitioning to less restrictive or less institutional settings. And so we do that now as people enter the SODCs. We identify those areas that could be worked on. It comes down to choice, though, as one of those big pieces, as well as like clinical recommendations. So our clinicians look and say, where are folks? Where can they be? What additional supports do they need? And so it is always available for folks to go on the transition list and to work with our transition specialists in and out of the SODC and working in private ICFs as well, to encourage folks to consider community options. And annually we ask folks if they would like to do that. But it is really, we believe in choice as the primary here.
Okay. All right. Thank you, everyone.
Is there any other members seeking questions or recognition? Okay, then before we do that business, I have to put Mussman in the chair, so Mussman is now in the chair.
Mussman in the chair. Minority spokesperson Reich, do you have a question?
Thank you. DCFS has a manual that deals with investigations. It's called Procedures 300. It's in the Administrative Code, and it's about that thick. Do you have a similar document or set of guidelines that you adhere to when you do investigations, such as the investigation here?
We are happy to explore and look at what happened. OIG, I don't want to confuse investigation. Sounds to me like Office Inspector General.
I'm using the word investigations in terms of your analysis of the particular situation you're confronted with.
I mean, we would look at a root cause analysis. I thought you were going into a direction about manuals. I was going to say we do have an ISC manual that references our case managers and how they are supposed to work with people that are looking for services.
Could we get where is that available?
It's online. I'm happy to share it with staff after this.
Please do. Mm-hmm. Is there any way that you can tell me or quantify how many instances like the one we have here that have been denied services but then granted services after the parents have given up custody of their child?
So for adult services, for adults, if a parent or a guardian decides to transition, it would be to Office of State Guardian. So the Office of State Guardian might have something like, we don't have that information. DCF, obviously in youth, it would be DCFS and us, or if a parent decided to give up guardianship. But for adults, it would be OSG potentially.
If a parent gives up guardianship in a DCFS case, in a youth in care situation, mm-hmm. do you take over any of the administration of the services that you think that all stays with the agency? Okay. Mm-hmm. So I guess it would be kind of interesting to find out if in fact there have been denials of service that have all of a sudden gone away because the parent has, or the guardian has given up control and then hence handed those over to you. And I'd like to know if there are any cases like that.
We don't do guardianship, so that's not something.
I'm not talking about you doing guardianship,
okay.
But services provided to adults for whom guardianship has been given up. No, no
Our process does
services.
not change if, we are agnostic on who the guardian is, for adults. It doesn't matter if it's the parent or an Office of State Guardian or that sort of
That's
thing.
not my question.
They still would go through the same
My
process.
question is denial of service under one set of circumstances and all of a sudden granting of services under
Mm-hmm.
a situation where guardianship or whatever legal thing is in place
Mm-hmm.
has been surrendered.
This, I think, goes to your question about rule, and, we have Rule 120, which governs our waivers, our home and community-based service waivers. We also have waivers that we have to submit to the federal government for approval, and that outlines who qualifies, the process, and that does not speak to, there's no difference between if a person does not have a guardian, if they have a guardian that is a family member, or they have the Office of State Guardian. The process is the same for all.
So I guess my question is, did this case just fall through the cracks?
I mean, we were working, my colleagues, the ISC was working with that family. I understand, and I'm saddened that it took so long, and we have been taking steps for systems-wise to try to improve and identify, frankly, for a lot of the things you talked about. The long-term stabilization homes, I think, is a good example, and trying to expand our SST and our stabilization homes and increase, frankly, pays to grow the number of SILAs available, so there are more choices for people available.
So I would recommend that if there are statutory provisions in place that allow you to do the things that you are empowered to do, that you explore the administrative rulemaking process to be able to determine how that is to be implemented, and you bring stakeholders in, such as this parent right here, who can give firsthand testimony as to what works and what doesn't, what fails and what succeeds, and then you go down that path and you engage stakeholders, SILAs, the Murray Centers of this world, those kinds of things, as well as the things that your staff people do in order to determine where those things go, and you set it down in a specific rule, so this kind of thing never happens again.
Thank you.
Thank you.
Representative Deering.
Sorry, one other last question. Addressing Representative Meyer's consideration that there is a termination consequence for employees that violate procedure. I mean, this is an interesting instance in that you said there is no such statute that your employees suggest to parents that they relinquish control in order to be able to receive services. If in fact it is determined that that happens, or in any case where you may have an employee who has misrepresented themselves, the agency, et cetera, as documented and verifiable, what are potential consequences?
We have internal processes for disciplinary action, which includes retraining, it includes documentation, it includes progressive action for kind of any missteps for employees. So it would depend on the specific situation and that sort of thing, but we have internal processes for that.
And are those notes included in their personnel file?
I think following that process, yes, the supervisor would discuss the situation. Sometimes the situation is retraining. Sometimes the situation is more significant or progressive and therefore is more consequential. It kind of depends on the situation.
So in this case, if such an employee has been determined to have misrepresented the option to this parent, you could report on such a thing back to this committee.
We could discuss, I'm not ready to talk about individual cases. I would want to hear about this. So but yeah, there would be, I think, corrections. So that's why I'm interested in learning more, frankly.
Do we have further questions from our committee members? Okay, thank you, Representative.
Can I just, for in closing, as I hear of all the great plans for DHS, and I really hope they work out. There's a lot of them. But, I've presented another bill in committee that they had all their organizations that they fund even slip in against it, just about readmission to an SODC. Now, for a parent like Danita, who has been through hell for the last year, Murray Center was the only place for her to go. When we started working on getting Gregory there, what did I tell you? I said, we will hopefully someday be able to get him into a good SILA, didn't I? That's anybody's goal. But if I was in her shoes, and I know that I moved him into a SILA to try it, to see if it's going to work, and I am no longer guaranteed that I ever can put him back in an SODC, because it's the wishes of DHS, which they put in writing as we were in the readmittance thing they sent out to people. They said that they don't think people should be able to be readmitted because it's going against their plan to get everybody out of these centers. Well, without giving a family an option of coming back if it fails, she's not going to try to take Gregory out of there. He went through hell, she went through hell. And, you know, it shouldn't be that way. Leave that guarantee there. If it's such a great fit, then you don't need to worry about them coming back. But until we can give those families that guarantee, any of them that have been through what she's been through is not going to try it. So I know that's a little bit off of this specific bill, but it's a major part of the situation these families go through, because they want that guarantee yet that when they found something that works, that they can go back to it. They're not afraid to try something new, but if it's failing, and they're the ones to blame that their son or daughter can never get back in the facility to take care of them because they were willing to take that chance. So I really appreciate the committee and the questions today and the hearings. I wish that I could sit down with DHS and have meetings where we try to work together instead of whatever Rep. Meyer says everybody has to file in against, because that's not my goal. My goal is that every family in this state that has somebody that's disabled, that that child and that family have to have the best chance at life that they can have. Thank you.
Thank you, Representative. So thank you, everyone, for a robust conversation today. I know that we will continue to see bills from you, Representative Meyer, that we hope further the discussion that we're having with how to best take care of our residents experiencing distress. But currently, there is no further business before the House Adoption and Child Welfare Committee, and we will recess to the call of the chair.
Croak.
Here.
Manley. Here. Auguste. Here. Coffee. Here. Davids Meyer. Delgado. Gone Gershowitz. Present. Mayfield. Here. Spain. Williams. Cochran. Here. West.
With 8 members in attendance, a quorum is present. So today we're going to hear House Floor Amendment Number 1 to House Bill 4814. That is going to be presented by Representative Cochran. Would you like to present from your chair?
Yes.
All right, wonderful. Okay, so you are recognized to present House Floor Amendment Number 1 to House Bill 4814, whenever you're ready.
Thank you, Chair. I'm presenting Amendment 1 to HB 4814 on behalf of Representative Didich. This is a technical amendment to clarify that the debt management service providers can charge the statutorily provided fees on a monthly basis. They currently can charge those fees on a monthly basis, and the amendment clarifies that we're maintaining that status quo. IDFPR had identified that the underlying bill may have accidentally created confusion about the frequency that those fees can be charged. So this amendment ensures that there is no confusion and that we're maintaining the frequency that it is under the current law. This amendment does not make any substantive changes to the committee, to the bill that the committee previously approved unanimously. I thank you for your consideration.
Thank you. So witness slips, there are 0 proponents, 0 opponents, and 1 in no position, which is IDFPR. Any questions? Spokesperson Auguste?
No questions of the sponsor. Don't we have 9 members present? Should have 7 members to the box.
Oh, I am sorry, 1 second. Yeah, 1 moment. Yeah. Clerk, can you please add Leader Delgado to the roll? Okay, thank you. Now we have 9 members present. Thank you, Spokesperson Auguste, for looking out for the committee, as always. Do you have any questions, though, as it pertains to the bill? Okay, great. Any other questions from members of the committee? Okay, great. There being no further debate, Representative Gone Gershowitz moves to recommend House Floor Amendment Number 1 to House Bill 4814. Oh, can we please add Leader Spain to the roll? Okay, so now we have 10 members. Amazing. Okay, so just real quick, there being no further debate, Representative Delgado moves to recommend House Floor Amendment Number 1 to House Bill 4814 be adopted. Is there leave?
Yes.
Fantastic. There being 10 votes in favor, 0 votes opposed, and 0 voting present, House Floor Amendment Number 1 to House Bill 4814 will be favorably reported to House Floor. Thank you very much, Representative Cochran. All right, there being no further business, the House Financial Institutions and Licensing Committee will recess until the call of the chair. Thank you, everyone.